And standing in the hallway at the federal court, I said to the witness, I said, they say you don't have a degree. He looked me straight in the eye, John. He said, I've got a degree. I said, hey, give me your transcripts. I'm going to show this guy. So Monday morning, I called him because I still didn't have his transcript. And I said, you're the first person on the stand this morning. And you're going to have to testify about whether you have a degree or not.
What was he doing?
He was in the bathtub.
What, are you like, get the court, dude?
Yeah, I had heard the water splashing, and I was thinking, like, I'm a Godfather fan, and there's Frankie Pantangelis, right? Laying in the bathtub. Yeah. I thought, this guy's going to off himself instead of coming to court. So he shows up at court, and I said, well, Sergeant, do you have a degree? He goes, I don't. Chief of police is standing next to me and said, you're fired.
Oh! All right, everybody, welcome to another great episode of Cases Gone Wild. We have a great show for you today with a great attorney and good friend, Mike Weaver, who we've battled. You're going to hear trial lawyer battles that you're going to hear about today. I'm Jon Marko. I'm your host. I've been an attorney for over a decade, and in my career, I've seen some of the craziest, wildest cases. Some have been with Mike that you're going to hear about today. And we're going to talk about these on the show. We're going to break it down for you. Remember, we're filming live. We dressed up for you, so go on the YouTube channel, watch us on YouTube, share with your friends and family. So let's get right into it. Mike, welcome on the show.
Hey, John. Good to see you. Pleasure.
You know, you are a formidable opponent.
You're too kind.
Sometimes an annoying opponent to me. I don't like to see you on cases, which I think you should take as a compliment.
Well, I'll take it as a compliment today. You're certainly a worthy opponent, a skilled opponent, and your track record, it speaks for itself.
Yours does
you're on
too,
a roll.
Mike.
Thank
Yours
you.
does too.
Thank
And you know what? I have a lot of respect for you, and I really mean that. And in this business, I don't have sincere respect for a lot of some of my opponents, and maybe that's arrogance, maybe that's ego, you know, whatever. I have a lot of respect for you. And I was thinking last night, I was excited that you were coming on the show, and I was thinking, what about Mike Weaver that I respect? And I have three things that I want to tell you.
All right.
Sincerely. Number one, and as you know, which is important to me, is you try a lot of cases. You try some more cases than most defense attorneys I know. I'd put you in the top 3 in Michigan.
Oh, thank you, John.
John Eads, a couple others, but you are up there. You try a lot of cases.
Yeah.
Number 2, you're tenacious. I mean, you've called me on cases on Sunday at 8 o'clock, and we've talked for an hour about cases. You're always working. You get up early. I mean, you put in the work, which a lot of people aren't willing or don't want to do. And 3 is the breadth, which I think speaks volumes. Like, there's a lot of attorneys who will stay in one lane. Like, I just do auto accidents. Mike, I've seen, I just learn every day about new freaking cases you do. I'm up in Oakland County. I walk in a courtroom. I see you in the middle of a trial. I'm like, what are you doing? Well, it's a business case. I understand you're in trial right now on an education case. I've seen you on employment cases. It's hard to take on all these subject areas, isn't it? To have such a breadth.
It is, but I think, John, when you say these comments, they're really comments about you as well. I mean, if you've got passion and you're willing to work hard, you can succeed for your clients. And really, it's all about making sure we succeed for our clients. The individual accolades are kind of secondary. We get into this business because we want to serve people. And I know this. You don't have to be the smartest lawyer in the courtroom. You just have to work harder than the other guy. And I see that in you all the time. Any guy who's tried as many cases as you have in any given year, you try more than most. And it means you're working hard and you're working every day of the week. You may be at a Lions game, but you're thinking about your cases.
Right.
And that's what it takes to be successful. And I think if you lined up all the successful trial lawyers in town, you'd find out they all have at least that one quality in common. They work really, really hard.
100%.
Yeah.
And there's no shortcuts. Like for those out there, like, how do I be a better lawyer? How do I do this? I wish there was just some secret. But as Jeffrey Feiger said, he always said, the secret sauce is it's a lot of hard work. And so there's no shortcuts to that. And you have to care, which goes into it as well. But so tell the viewers, so you're a part, so you do defense work. You're at a very well-respected firm, big firm in Michigan, Plunkett Cooney.
Yep.
You're a managing partner there, right?
Well, not a managing partner, but I'm a partner.
You're a big-time partner. You're the guy they go to.
I'm an old guy.
You're the guy they go to when things are going to hit, the rubber hits the road, when there's going to be a trial. They bring you in.
I'd like to say that's always true. We've got a lot of really good trial lawyers, but I enjoy trying cases. Some people don't enjoy trying them as much as I do. And so I kind of look for those opportunities.
Yeah, well, good. Well, I'm happy to have you on the show.
Thanks.
We're going to get right into it. I know you want to talk about civility today, but we are on Cases Gone Wild, so we're going to talk about some cases. So tell me, let's talk with civility, because I'm really happy that you said, John, I want to talk about civility. It's something that, do you think it's something that's lacking in our profession? And is it getting worse or getting better or what?
I think it's gotten worse since COVID. And I kind of akin that to keyboard warriors, right? When we were all, you could send an email or post something and it was sort of anonymous. People were pretty brave, right?
Right.
And it's kind of gotten that way with COVID. We're not seeing each other in court every Wednesday in Oakland or every Friday in Wayne or every Monday in Macomb. And you don't get to know the people that you're fighting against. And so it's much easier to take pot shots on a Zoom. And I think that that's really become a problem. It's a lot of pressure, our job. And during the trial I'm in right now, Judge Gibson in the Wayne County Circuit Court swore in a brand new lawyer. And I listened to the oath for Michigan lawyers. And can I just quote a bit of it?
Yeah,
all right.
yeah.
What it talks about in the oath is that you promise for the right and the privilege to be a lawyer and practice in the state of Michigan. You promise that you're going to be civil, not only to the court, but to your opponents. And that includes the litigants and the lawyers. And I listened really carefully to that because, as you know, in trial, emotions tend to run high. And I thought, all right, I want to pump the brakes here. I want to think about this, and I'm going to try to be better. And I think, I know Judge Cox in the federal court has said we're going to start coming back in person. I think that's going to help the civility. Federal court has their own civility policy that was published in 1993 by Chief Judge Friedman at the time. A lot of people don't know about it. And I would say most judges dislike the lack of civility.
Sure.
I think we all need to focus on that a little bit. But I've got a good example of a real good civility story between me and another lawyer that I was in a trial.
Yeah,
with.
I'd love to hear about it. And before, I want to say, I agree that I think it's getting worse. Like when I started practicing in 2008, and you saw the same people on Fridays down at Wayne County Circuit Court. That was motion call. It's a lot harder to be rude to your neighbor than it is some stranger on the subway who you're never going to see again. Yeah. And it's even easier to be rude to someone when you're behind a computer and you don't even have to say it face to face to them. Even if it's a stranger, but you are behind a computer. And a lot of these younger or newer attorneys have not had the opportunities that we had where you would go face to face with people. You might not get along, you might fight, but I feel like we have lost and are getting worse on some of this civility stuff.
Yeah.
And it's a shame, and judges don't like it. And, so tell me about this story. Tell me about this story.
So I was in trial in front of Judge Friedman, as it would be.
Federal court.
And it was a reverse discrimination case. The entity or governmental entity that I represented had promoted an African-American in the police force over a Caucasian.
And so reverse discrimination, for those who don't practice in this area, is basically a white person saying they've been discriminated against.
Correct. Right? Yeah. And so we got all the way to trial.
And you're the defense attorney,
I'm
right?
the defense attorney. The plaintiff attorney is a great guy, longtime lawyer, focuses extensively on employment cases and been very successful. And he had the successful candidate on the stand, the guy who got the promotion to sergeant. And that guy, consistent with the theme that I stated in my opening, had a college degree, but the unsuccessful candidate, the plaintiff in our case, did not have a college degree. And that was the point that delineated the two so that the defendant got the promotion. And he went through and he testified, absolutely. I went to Western Michigan University, got my degree in 1987 or whatever it was. And at the end of the trial
So
day,
qualifications were important, right? Because
Yeah.
it's like in an employment case, it's like, look, you hired a less qualified guy, right? Was that the argument? Or?
yeah, the argument from the plaintiff was that the plaintiff was more qualified than the defendant. The defendant's position, the city that I represented, said, no. The big distinction between the two candidates was the successful candidate had a college degree.
So education was very important in this trial.
Very
right?
important.
The educational qualifications, right?
It was a big deal. And at the end of the trial day, plaintiff counsel said, you got problems. I said, what is it? He goes, your guy doesn't have a degree.
What? The guy?
Yeah.
So you're representing the employer, and the employer said, look, we hired this guy because of his degree, and it turned out that wasn't true. Did you know about it?
Nobody knew about it except for the guy who perjured himself on the stand.
And this came out in the middle of the trial.
Came out in the middle of the trial. And plaintiff counsel said, listen, I didn't want to embarrass him on the stand. Incredible showing of civility.
That is insane. Because most, I got to be honest with you, Mike, I would have went for the jugular in front of the jury.
Oh, I would have killed him. No question about it. And so that happened to be on a Friday. And standing in the hallway at the federal court, I said to the witness, I said, they say you don't have a degree. He looked me straight in the eye, John. He said, I've got a degree. I said, hey, give me your transcripts. I'm going to show this guy. And we're all set here, right? We're going to win this trial. So he says, I'll do it. So Saturday I called him. I said, do you have your transcripts? He goes, no, I'm going to work. I got to work on this. I'm working on this. I said, okay. So I called him on Sunday. I said, do you have your transcripts? He said, I can't find my Bronco ID. I said, hey, it's crazy. I'm looking at the Western Michigan website right now, and there's a little button you click that says, I lost my ID number.
Yeah, you can get it online,
yeah,
right?
you can get it online. So Monday morning, I called him because I still didn't have his transcript, and I said, you're the first person on the stand this morning, and you're going to have to testify about whether you have a degree or not.
What was he doing?
He was in the bathtub.
What, are you like, get the court, dude?
Yeah, I had heard the water splashing, and I was thinking, like, I'm a Godfather fan, and there's Frankie Pantangeli's, right? Laying in the bathtub. And I thought, this guy's going to off himself instead of coming to court. So he shows up at court, and I said, well, Sergeant, do you have a degree? He goes, I don't. Chief of police is standing next to me and said, you're fired.
Oh!
So, again, a showing of civility, plaintiff counsel said, I'll just take a stipulation that he doesn't have a degree. Instead of putting the guy on the stand, and as you said, going for the
Yeah,
jugular.
wow.
Yeah.
Did the guy like have a fake diploma or something? Like,
He just lied about it.
but see, those things, I mean, like, you kind of like take it for granted almost, right? Like, I'm assuming you're preparing for the case.
Yeah.
You know, your client says, I have a degree. They have it in the records, his resume with the degree.
Resume, job application, everything says he's got a degree from Western Michigan University.
That is wild.
He never even attended.
Wow. So what happened with the case?
He ended up getting, believe it or not, the jury was out for 3 days. And plaintiff counsel got a verdict against my client.
So justice was done.
Justice
He handled it in a very civil manner, right? Because he could have done a lot of, he could have called you a liar, right? And, wow. So that's a crazy story. You know, I had a case, I always find, and I was talking to you a little bit, earlier about this, but like, and I've said this on the show many times, when you start trying to weave webs of deception, it usually backfires, right? I mean, especially in a trial, our whole system, right, is to try to get to the truth. And you put good lawyers on each side. You have a jury to decide the facts. We want to make sure we look at things skeptically, right? So like, I always assume the defense is lying. You probably always start at the baseline. Let me make sure that the plaintiff is telling the truth because of these experiences we've had. But like, I had a case once a long time ago where there was these two important papers, there was paper one written to the employer and paper two. And I came in late and I really wanted paper one because it was like this like beautiful, I'm like, this is the best exhibit ever, right? And we couldn't figure out. I asked my client, I said, which one did you give to your employer? Which request? And she looks at me and says, John, honestly, I don't remember.
Fair.
I said, fair.
That's fair.
I said, then you know what? Just say that. Just say that. But my co-counsel at the time, this was a long time ago, this guy said, well, if we tell her to say it was paper one, she'll say it. Let's just tell her she needs to say that. I said, I'm not doing that. I said, it's
Amen.
going to lead to problems.
Yeah.
And what are we going to do if this comes out one way or another? They're going to think I'm a liar. They're going to think you're a liar. They're going to think she's a liar. Nobody's going to get anything. It really backfires, you know. And it's unethical, first of all.
It's really unethical. And we've all kind of had that crossroad in our careers, maybe more than once. I mean, I had a client one time, we were producing, this is back in the day when we produced stacks of documents instead of a thumb drive or just electronic through a link. And I had all the documents and I said, this document is really bad. And he said, well, don't give it to him. I said, no, I'm giving it to him. It's unethical to withhold it. And if you ask me to do something like that again, I'm never going to represent you again. 20 years later, I'm still representing this company.
Yeah.
And we won the case.
That's my case too. We won anyways.
Yeah, we won anyways. Yeah. So listen, as a lawyer, you should never compromise your ethics. You really, in our business, you just have your name.
You have your name. Credibility is everything.
It is.
Credibility is everything in front of the judge, because if you get caught doing something like that, that judge will never forget it. Right?
And she'll tell her friends.
Credibility is everything in front of opposing counsel. Because if you go, you know, what's one of the first things you do when you get a new file with somebody you don't know? You know, you call up, hey, you know this guy or gal, you know? Oh, that guy's a liar or that gal's a liar. You know, and the jury, right? If you're trying a case, you lose credibility, it's over.
It's all over.
It's
no
over.
No question about it.
So tell me some more about some other crazy cases. We had a case together, a long case. It went on for
3 years, 4 years,
4 years at least.
Oh, it went up on appeal and back.
It went up on appeal.
That's right.
And you do a lot of school district work.
I do.
Right? So you represent schools that get sued, which they do get sued.
Yeah.
You know?
Yeah. Even with governmental immunity, they get sued. In our case, you know, like I thought there was a really good governmental immunity argument in our case because it wasn't a defect of the public building, right?
I didn't think there was a good
I know argument. You didn't, but you turned out to be right on that one. In our case, as you know, the mullion, the part of the door frame fell and hit your young kid.
So we had a kindergartner.
Yeah.
And just so our listeners understand, there's special protections for public schools, right?
Correct.
So it's really hard generally to sue the schools, right?
Yeah.
Like normal stuff, like you slip on ice, there's no case, right?
No
like
case.
Something like that. But one of the exceptions that you can sue a school or a government is if the building itself, a public building, has something defective with it, right?
Yeah.
And so in this case, we had a kindergartner who was walking outside for recess or something, and the door frame, which you correctly termed a mullion. Right? Was like decrepit, decayed, had been spot repaired a bunch of times, and collapsed and fell on his head. Right?
Yes.
And so this case went on for a very long time for a variety of reasons. We took a ton of depths. You drove me crazy. You litigated the case heavily. You got a good result for your client.
We had a good result, but you had a good result for your client.
We had a compromise at the end, and maybe justice was done.
Sure.
But it was an interesting case, I thought, because we did a scene inspection. We went out to the school, and I don't know, is there budget problems or something? It just seemed like the school was on tough times.
Yeah, and that one, the school had outsourced all the maintenance, and the issue was whether this was considered a major repair or not a major repair, and that was a kind of an important term under the contract between the school district and the company.
And you had the school, right?
I had the school.
And so our listeners understand what the school had. Like when I grew up, we had janitors at the school, right? They worked for the school, right? Yeah. This school, to save money due to budgetary restrictions, had to lay off all their janitors, repair people, and then they contracted with a private company who you did not represent, right?
Correct.
I think you sued the private company, said they're responsible.
I did.
That was awesome, by the way. We like to see that. So the private company then brought in janitors who they didn't have to give all the governmental benefits to. They could underpay them, all that stuff.
No pensions.
Right? And they were responsible for, was it the major repairs or the minor repairs?
Yeah, I mean, it's weird because the contract wasn't, you and I didn't draft the contract, obviously, but the contract wasn't as clear as it could have been. And while it talked about checking the doors every night, The company's position was, well, that just meant making sure they're locked. My position was, no, you got to check the doors and make sure they're not going to hurt somebody. You got to make sure they're structurally sound. And that was the dispute between the school district and that repair company. And it ended up, and I think you're right, John, when you say probably justice was served. We probably got to the right result. It took a long time, but we got there.
Took a long time.
Yeah.
But yeah, and the other thing about when you sue schools or the government is you get an automatic appeal before a trial. The defense does.
Yeah. So there's something called governmental immunity. It kind of stems from the thought of the king can do no wrong. And we recognize that the government's there to serve, and we sort of give the government a little bit of blessing. There are 6 exceptions for governmental immunity. And whenever a plaintiff, a lawyer like you, sues the government, you have to make sure you plead one of those exceptions. And even if you do, the defense files a motion with the court, and we say, Judge, you have to dismiss this case because it's barred by governmental immunity. The king can do no wrong. And unlike any other defendant, if we lose that motion, if the judge says, no, Mike, I don't think governmental immunity bars this claim, we get an automatic appeal to the Michigan Court of Appeals, which does a lot of things. It gives some time for the parties to sort of regroup, but it delays any type of recovery for the plaintiff. And because the Court of Appeals is pretty backed up, it's 1.5 years to 2 years to get things done. And I remember on that particular argument, when you concluded your remarks, you said, make this a published opinion, because you were really confident that you were going to prevail.
Yeah.
And so the listeners should know, a published opinion has a little more weight than an unpublished opinion, right? So, and it was a published opinion, and you did prevail, and we went back to the Wayne County Circuit Court, and ultimately we settled the case.
We got the case resolved, yeah. And that was an interesting case because we had to prove, there's so many things you have to prove, but number one, we had to prove that there was a defect in the building, right? Which was this door frame. Yep. And then number two, we had to prove that the school knew or should have known about it. And we went out to the school, we took the door frame apart, and, it was pretty rusted, and you could tell they had repaired it a bunch of times. And we found, I don't know if you remember, we found a previous janitor, this old, nice African-American dude who had been like the janitor at the school like his whole life.
Yep.
And he blew the case open. He was like, yeah, I was telling those people they needed to fix these doors or it was going to hurt somebody. They were too cheap to fix the door. Remember?
It's clear that I didn't prep that guy well enough for his testimony. But yeah, listen, this guy, like everybody, I say, just tell the truth. Whatever the truth is, tell the truth. And that was his truth. And, maybe it was true, and it probably was true.
It was true.
And it was.
And he had no love lost for the school because he was one of the people that was laid off.
Yep.
When they just said, oh, hey, janitors, thanks for your 20, 30 years, but we're going with this cheapo company over here so we can save a couple bucks. So.
Yeah, that was, I think, the pivotal deposition in that case. So
yeah. But that was fun. You do all kind of other school cases, don't you?
I do. I've had some crazy stuff. I find that sometimes plaintiff lawyers will overstate things, and that really
overstate things.
Yeah,
never.
believe it or not.
We would never do that.
And I think if everybody gets reasonable early on, cases can resolve. But I had a case for a school.
It's hard though, Mike. Sorry to interrupt you, but here's we have a dance. Like good lawyers have a dance, because if you say, and I've been burned in this, but like I had a really good employment discrimination case, nothing to do with you or your firm. Okay. And the defense attorney, who I do not have respect for like I have for you, said, let's go to mediation. Let's be reasonable. And I gave like a very, what I thought, like
a real number,
like a number that was like so low, like I didn't even feel good about it. But then they used that against, and they didn't settle. It was all a ploy, right? But they used that against me for the rest of the case. They said, well, Jon Marko said 3 years ago, he would take
X number.
Right, yeah. So it's always a dance, but I'm sorry to interrupt you. So,
there's certain lawyers you get to know their dance, right?
Yeah.
And this one particular lawyer, it's always a massive demand. So there was a case where in a bathroom of a high school, there was a racial remark written. It was brought to the attention.
How bad was it?
The N-word.
Pretty bad.
Really bad.
Wait, like on a piece of paper or like spray paint?
On the wall, like with pencil or marker on the wall.
Okay. Like a big one, or like
it was
when I was in high school, like you'd go in the bathroom for a number 2 and they'd be like, Call Jenny. Like all these, all these doodles and stuff.
This was not a call Jenny, and it was the only remark on the wall. It was fairly faint, but it was clear that it said bad things about people and the N-word.
That's not good.
And so there were 7 plaintiffs, and plaintiff counsel's demand was multiple millions of dollars per, whether they saw this remark or not.
Did some people not see it?
Some of the plaintiffs did not see it.
Well, how do you have a claim if you're not involved? I'm not saying it's right. It's horrible. I do civil rights work. I do race discrimination work. But I wouldn't be able to bring a claim for somebody who wasn't affected. I mean...
So we took some depositions of at least, I believe, 2 of the kids and 1 set of parents. And it became clear that some of these people had not even seen it, but they heard it. And they were troubled that they had heard that this remark was on the wall. They ignored the fact that the district took immediate action to clear it or paint over it or whatever. I don't remember exactly what they did, but it created a real stir in the district for obvious reasons, with rallies and police involved and everything else. But I felt like the lawyer could have handled it differently. But to put this expectation out there that everybody's going to get multi-millions of dollars was not realistic, and it caused way more difficulty trying to resolve the case. And I didn't think it served any of the clients well, my clients, their clients, to continue on with discovery that was becoming very public, and worse, was creating a lot of consternation in the district among staff, students, administration, everybody, parents.
Very divisive, I'm sure.
Incredibly divisive. A great district, African-American superintendent who was troubled by it. And I just never really understood why that had to be that public, with press conference and news and newspapers.
Let me ask you, did they ever find out who did it?
Never found out who did it. We had video. There was a clear suspicion that one of the plaintiffs was the author. Because we had video of the restroom, and we knew everybody who came in and went out, but we could never prove.
They thought one of the kids who was suing did it.
Yeah.
Wow, that's wild.
Yeah, it was certainly within about 5 people. One of the kids that was suing was the person who did the writing.
And that's wild. That's not a good thing if you're on the plaintiff's side.
Yeah.
And just so our listeners know, like, again, when you sue the school for race discrimination, it's unless like one of your teachers does it, right, which is a little bit different.
Yeah.
But if it's a student harassment, the law is pretty tough. The school is not automatically responsible for the actions of the students, right? They have to have notice. In other words, like, it would have to be repeat. For example, like, they do it and then the school says, we're just going to ignore it. Go about your business.
It's a deliberate indifference standard, right? It means that the district, not only do they have to know about it, they knew about it and they said, we don't care. And that's a really tough standard for the plaintiffs.
Really tough standard.
And I'm not saying the plaintiffs haven't met it in some cases. This case wasn't it. But
because it was a one-time thing.
It was a one-time thing.
Even though it's horrible. I have cases like that. People come to me, they're like, this happened, it's horrible. I'm like, did you report it? Yes. What happened? Oh, they fired the guy right away, and it never happened again, and now everything's really good at work. I'm like, I'm so sorry that happened to you. That should not have happened to you, but we can't bring a claim against the employer under the law if they did what they were supposed to do. There's differences if it's like a manager and stuff, because, they are the company and stuff like that. Right. Yeah, that's interesting.
So we talked about, when you and I were talking this morning before we came on the air, videos.
Yeah.
So I think that is a more recent development in our profession, right? Everybody's got a camera now.
Everybody's got a camera.
Everybody's got an audio tape, right? Everybody's got the ability to secretly record what we're doing.
Right. It's in your pocket.
It's in my pocket.
You have a tape recorder at all times. It's not like back in the day. It's like I'm wearing a wire, in my undergarments or whatever,
So I've had cases where my client will call me and say, we've got this complaint from a parent or a student or an employee or whatever it might be. Will you come in and do an investigation? Absolutely. So who all would have had contact with this section of your facility or this group of employers or this group of students? Let's interview every one of them. And what's important in our business is I want to get it in writing, and I want to get it right now, and I want to get it while it's fresh in your mind.
Right. Memories fade.
Yeah.
What do they say? Memories fade. Witnesses disappear.
Or on January 10th of 2023, I get a written statement from you, and then you get fired a month later, and now you want to change your statement. I've got it locked in, right?
Yeah, right.
So I've had cases where I've gone out and done the full investigation, got all the written statements gathered, and we're pretty sure we're in good shape. And then I get a call from a plaintiff attorney. I said, you got nothing. I've talked to everybody. You want to come in and talk to these people? Hang on, you sitting by your computer? Yeah, let me send you this video recording. Uh-oh. Right? So remarkably, under oath or not under oath, sometimes your clients aren't exactly forthright with you. And
right. It happens on both sides.
Right?
Right.
Yeah. So that is a game changer. I mean, I think when we're in a society of shorter attention spans.
For sure we are.
And jurors are, God bless them, they're doing a great service for $20 a day or something, right? So they want to see something, and they want to see it now, and they want something powerful. There is nothing more powerful than a videotape of my employee punching your client or my employee saying bad things to your client, and superimpose that upon my client has already written a statement that says it's all false.
Right. So now is a liar.
Which is a liar. And I think that has been a huge change in our business. I started doing this in 1990. I remember when I got my first cell phone in like 1996. It definitely did not have video
Right.
or audio recording capabilities, right?
Right.
So it's a real game changer. And when I'm talking to my clients, I say, you should always assume you're being videotaped or you're being audio taped. You should always assume that and proceed accordingly.
Right.
Because if you're under that notion or that thought process, hopefully you're not going to do anything wrong.
Yeah.
Right?
It's good. I tell my clients, like if they have an HR meeting, like let's say they say, hey, John, I think I'm going to get fired.
Yeah.
I say record that meeting. You're legally allowed to do it. Michigan's a one-party consent state. What that means is you can't like put a recording in a room that you're not part of and then like secretly record other people talking.
Right.
But if you're part of the conversation, like let's say we were talking right now, and we have video camera and we have microphones stuffed in our face. We're obviously being recorded, but like let's say we were just chilling, I could record this.
Yeah.
So I always tell them that, and the reason I do that is so we know exactly what happened, because when people's self-interest, or they might be getting sued, or or they want to sue someone else, stories can change, right? We know that. And I think that video, that video is good for everybody. That's why I think body cams are good. I think it's helpful because when I have a client and they tell me there's a video, the first thing I'll do is listen to the video. They could tell me anything else. I'm like, look, that's not what's on the video. I'm sorry. I can't take your case, right? Or vice versa, vice versa.
So what do you tell your clients to disclose they're recording the meeting or not?
It depends. Like the Blue Cross case I just went on, we had a recording of the interview process, and she said right in the interview, can I please record this? Right? But generally, no. I don't, there's no requirement to do it, but I also don't want my client to look like they're sneaky, because jurors, if they think that your client is trying to like set someone up, that can backfire as well. So it's a case-by-case specific thing. So
I have a case, or I had a case, this is a long time ago. Under the court rule, if there's going to be a mental evaluation, it can be recorded if you have a court order.
Yeah.
So this plaintiff decided to secretly record the evaluation. And I filed a motion to keep it out because you can't do that without a court order. And the judge agreed with me. And so I think that's a case where it seemed like someone was trying to be sneaky.
Yeah.
Right? And so if that would have come in, I would have talked about when you secretly recorded that, when you clandestinely recorded that, when you didn't tell anybody you were recording that, right? Because that gives the implication that I was pretending and being on my best behavior and baiting them into being on their bad behavior.
Right. That's right. You have to be careful with it. But I say, look, if you're going to an HR meeting that you think you're going to be fired and you haven't done anything wrong, I think you should record the meeting.
I don't disagree.
Because and in my last trial, this Blue Cross trial, for our listeners, it was a biggest vaccine verdict and the religious accommodation verdict in the history of the world. We had, in that case, we had an issue with the recording. And so it was very helpful that we had it because everybody agreed this was what was said. But what happened in that case is the HR person said, we don't want any witnesses to this interview process. And we have them on recording having the HR person saying, we don't want to have any witnesses. And so why, as an employer, I said this in my closing, I said, who doesn't want witnesses around? Criminals.
Yeah.
Because the good guys want to make sure that there's as many witnesses around as possible so they can say exactly what happened. And why would an employer specifically not want witnesses to what was about to go down? So that was the flip side, right? Like, thank God we had that recording. But it helps. I agree. It's so powerful. Another thing that I'm sorry, Mike,
you had a verdict up in Washington recently with a video.
Yes.
I mean, I've never taken away from your skills as a trial lawyer, but you almost could have just said, here's the video. I have no further questions.
And sit down.
Yeah.
Yeah. And we talked about this on another show. We had a video of a oil change shop where a car literally drove one of the workers into a wall and pinned him into the back wall at a high rate of speed. The guy hit the gas instead of the brake. The injuries on that particular case were not comparatively bad to some of the things we see. The guy didn't break any bones. He didn't have any surgeries. His MRIs were all clean. So why was that case worth so much money? The defendant lied and it was on video. And I mean, there's something about seeing a guy, you can describe getting slammed into a wall like our listeners are hearing right now about by a vehicle spinning your body and crushing the muscles and whatever. But to see it on video, they say a video is worth 1,000 words, right? Photo's worth 1,000 words.
No doubt about it. I had a case recently where, it's a few years now, where
I know, but it always feels recent.
It does feel recent. Yeah, you never forget them, right? But I had a case where the allegation was that some special needs kids were hit or slapped, and interviews were all never happened. Video. And while much like your case, John, no one went to the hospital, no one was cut. But the videos were really powerful and it led to a settlement in the case.
Exactly. We had another one, we start spitballing and then all these things come to mind in our careers, right? But we had a case in Macomb County against a private childcare facility. They provided, you take your kid there and they watch your kid, right? I don't know what it's called, but, and the kid was having scratches. Nothing serious, no broken bones, but the kid started acting weird. The kid started becoming scared to go to the facility, and there was video of one of the attendants or whatever, the employees, literally like slapping a kid in the face and holding the little kid down because the kid was crying, the little baby was crying, and then she became frustrated and was like holding its arms down and like body slamming it into the ground. Now, look, if I told you about that case, you would say that's wrong. It's probably worth some money, but it's not worth a lot, comparatively speaking, at least the way that we evaluate cases. Now, you show somebody a video of their child, helpless child crying and a mean person. You show them that video, they say, oh, that case is worth a lot of money. Right? It changes the dynamic.
No doubt about it.
One thing you said that I totally agree with and I think is insightful is that jurors' attention spans are different. And not just jurors, humans. All of us. We're on our phones all the time. We're getting news from multiple sources, high rates of speed. We're scrolling. We process, receive, retain information differently than they did 100 years ago, 50 years ago. 50 years ago, I read books. I love to read books about previous trials. One of the most famous trial lawyers is Clarence Darrow. I read these stories about Clarence Darrow doing a closing argument without any exhibits or props for 2 days. Can you imagine A jury sitting, just listening to a guy talk for 2 days.
No.
I'm lucky if they listen to this whole podcast, which is about an hour,
So
right?
don't you got to keep your opening to around 30 minutes?
30 minutes,
Yeah,
yeah.
couple visual aids in your closing around 30 minutes. Pop up a couple exhibits on a screen.
Right.
I don't think the jury wants to hear from me any longer than that. And I feel the same way on direct, and if at all possible on cross,
Yeah.
to be as short as you can, but still hitting all the points that you have to hit.
Have you changed how you present your cases compared to when you started?
Yeah, I'm definitely shorter. I definitely use more visual aids, more exhibits. I mean, I still use an Elmo.
Yeah.
Because I think it's the easiest. The Elmo's like when we were kids, it was an overhead projector at your school
Document
library.
camera.
Yeah, that's all it was. So everything becomes a big blow up and you put it on the screen.
And so our listeners understand it used to be those huge boxes.
Yeah.
But you put a piece of paper under it and it projects it automatically onto the TV.
On the screen. So
And that's
use
amazing. It's easy and it's versatile. I agree with you.
It's indestructible, too. It's
Indestructible.
infallible. It's fantastic. And so I use it all the time, especially in closings. And I'll highlight testimony and I'll say, look at what they said. Here's what they said. Remember that? And I'll tell them why it's important. I'll put up, maybe 5 or 6 really important exhibits with highlights on it and
Yes.
say, when you go in the back, look at this book. But then I
Exactly.
try to get in and get out and be done.
But
I've had lawyers who, on cross-exam of my experts will be 2.5 or 3 hours. I think you lose the jury.
I think you lose the jury too, unless you really got a lot of stuff. I mean, they get the point, right? You gotta come out with a bolo punch to the face. That's always my theory.
Yep.
I come out, I blow them down right away, and then especially experts, and then you can go through the rest of your stuff. I agree with you. You have to show exhibits. I try to show, don't tell me, show me, right? So like if you have a medical record, I like to put it right up on the screen, show it rather than say, did you say this? And just have the doctor say, yes, I said that this. Well, let's show a medical record so the jury can see the medical record and hear from the doctor at the same time.
2 senses.
2 senses. And, some people are visual learners, auditory learners. And I try to show as much as possible. And I had a recent trial in Oakland County where the defense attorney was a very experienced defense attorney. He lost big time. He hadn't lost in a long time. We won $7.9 million. And he was old school and he didn't show anything. And when we talked to the jury said, look, when Mr. Marko told us something, he showed us. Instant credibility. I'm not making this up. When the defense attorney, he wouldn't show them anything. And then sometimes he'd say things and then I would show things that showed what he's saying wasn't entirely accurate. Maybe it was accurate in the way that he was saying it, but he should have showed it,
So I already have my closing pretty much prepared for my trial that I'm in right now. I have 15 exhibits that I'm going to show to the jury.
Good.
I only have 30 minutes. By judge order, I have 30 minutes. So I got to bang them out pretty quickly.
That's hard to do.
It's hard, but I realize that primacy is important, right? So I'm going to hit them with something really important at the beginning and probably say the same thing, very important at the end, hoping they remember that key point.
Right.
So
yeah, that's a good strategy. 30 minutes is really tough though, especially for closing argument. I always find myself rushed. The trial I just did, the Blue Cross case in federal court, I was rushed at the end. So I didn't get to go through. I should have made it shorter. I'm long-winded. I tell the jury right up front, I am long-winded. I am sorry. I can't help it. I'm going to do the best I can. But even with that, and then when the judge said you have 5 minutes left, I said, see, I told you I was long-winded, and they laughed a little bit, but they were ready. But it's hard to get to distill because you don't want to miss anything. You don't want to go back. I mean, every dep I've ever had, I don't know about you, but I leave and I'm an hour or 2 hours later, I'm like, damn it, I should have asked this question. How did I not do that?
And you do it with closings, you do it with openings. I get it. And, it's all rooted in a goal of I want to do the best I can for my client. And, I get it. Judges have every right to say you get X minutes for this process or openings or closings, whatever it is. It's their courtroom. They're allowed to do it.
Right.
But we have to follow that rule. And it's imposed on everybody. It's not just on defense lawyers or just on plaintiff lawyers. So it's evenly applied, and that's fine. But it does make it hard to make sure you got all your points. And I tell a jury, and thank God there's not manual court reporters anymore, because they used to stop me and say, you're talking too fast.
Yeah, and just
Slow
so our
it down.
listeners know, there would be a literal person in the courtroom with a type machine. It's called a stenograph machine, typing down everything you say as you say it, right?
Yeah.
Now it's a box. Now it's a computer. They record it, and then if they need to type it up, they send it out to a transcriptionist later.
Yeah.
But
so that has helped me be able to talk as fast as I possibly can to still get the message across, but get everything in my 30 minutes that the judge
and I
allows
think
me.
people are used to us talking faster than 50 years ago or something.
No, listen, commercials are 15 seconds, right?
Yeah.
And they cost millions of dollars.
Right.
So yeah, I mean that again goes to the attention span of the public, ourselves included, is shorter than it used to be.
Yeah.
Right? Yeah.
And we're used to like fast-paced movies now. If you watch like old school movies, they're a lot of slower. They don't have as much camera cuts. Now it's like our brains are just hammered between our cell phones, which is all the time, and news. You got your 3 computer screens, and you got your radio on, and you got the TV on the background. We're just it's like ADD mania, So for me, it's fine, but
TikTok videos are 15 seconds or something like that, right? And people love them,
right?
And they get the whole point, and the whole story is told in that time. So
Yeah.
I think that's even in jury selection and in openings and closings, and then direct or cross examination. I think you got to be thinking about that all the time.
What's the longest trial you've ever done?
I think I had a 6-week trial over in Grand Rapids a long time ago.
Long time, man.
I don't think
6
they'll do
weeks,
that anymore.
dude. Have you ever been on a 6-week vacation?
I think I had 1 2-week vacation. It was last year after 33 years of practicing law.
Exactly, dude.
Yeah. So, I mean, I don't know that anyone does trials that long anymore. I don't know how you keep a jury that
Griffey
long.
was 6 weeks.
Was it really?
It was 5.5. But it was a long It was a long haul.
That's a long trial. What no one really cares about is your whole office is still going on.
Yeah, right.
So every night when you get home, not only are you preparing for the next day of trial, you're preparing to put out all the fires that occurred.
200 emails, full voicemails. Oh yeah, what about your kids? Oh yeah, I have to make sure my kids are alive. It's like, it's tough. What was your 6-week case?
It was a case that involved there was MDOT and some contractors. This woman drove into a construction zone, and a big earth mover rolled right over her.
What?
With her child in the back, and the child was unscathed, and she perished. And the plaintiff lawyer brought in the child to testify on the Friday before Mother's Day, which was pretty powerful because his mother had died, right?
Oh, my God.
But it was a long trial, and so we had MDOT, so it was a bench trial, meaning no jury for us, but the contractor had the jury. So we were
at the same time in the same case.
Yeah.
That's weird, dude. I've never heard of that.
Yeah, it was pretty cool. It was
so you represented MDOT, which is the Michigan Department of Transportation.
Yes.
And
the issue there was the signage was confusing. There's a manual, uniform manual for traffic control devices, and it's published, and it says when you're in this type of construction zone, you have to have signs at this sequence, and this is what each sign has to say. And the argument was that the signs were confusing and not consistent with the manual.
Well, I mean, I think everybody out there has, when there's a new construction that you're not used to, and some are set up better than others. Some, they got barricades, and it's like, okay, I know I need to do this. But I've been driving to where, I'm in Grosse Pointe. I drive to Detroit every day, and they're doing road work, and it's like some bozos. I'm like, do I go in this lane? Do I go in this lane? You almost drive in oncoming traffic because it's just cones they set up. And sometimes they are confusing, Mike. And it's like, where the hell am I supposed to go, dude?
It's confusing. And let's be honest, we all hate road construction.
Yeah.
It is the bane of our existence, even though we're thrilled when the roads are pristine and nice and fixed and all that.
But they're always being
it's
constructed.
Terrible.
Yeah.
I come through Square Lake on the way to and from the office. For 2.5 months, westbound Square Lake was closed. Now that's open. For the last 2 months, eastbound Square Lake is closed, so now I drive through and cut through Pontiac on the way home.
Yeah.
And I just why aren't
all
these
the
roads
time,
done,
dude?
right? But
it's all the time, and it's so slow.
Yeah.
not to get off cases gone wild,
Yeah.
but like when I lived in DC, when they did a road repair, they would work from like 12 a.m. until 8 a.m. to get it repaired, because if they didn't do the repair quickly, it was already gridlocked with the road
Right.
fixed. It would shut down the city. They did it differently. I don't know why, but fix the damn roads. So, all right. So what happened in this? What happened?
So ultimately,
She got ran over by like a steamroller?
big earth mover that has the bucket underneath with all the earth in it.
What's an earth mover? Describe it for the viewers.
The wheels have to be 15 feet high. And it had this huge bucket underneath it, and the driver was up above it. And
What was it? What would it do with the bucket?
it had the big dirt. It was taking it from one side of the old road to the other side.
and spitting it out? Did it
and
have
then
like
spit it out over there.
Did it have like gears and drills or something in it? Or?
No, just a big shovel underneath.
Shovel, okay.
Yeah, it was a big shovel underneath. And
So this lady drove into an area that she unwittingly wasn't supposed to be in.
correct.
And the earth mover drove over her?
Right over the car.
What happened?
She died at the scene.
Did it like crush the car
Yeah,
up?
crushed the car. But the
Why'd
child,
the guy drive over her?
he never saw her. So
Did it
that
happen
was a
quickly?
construction guy. It happened quickly. That was the construction guy. So there was another lawyer representing them. My client was Michigan Department of Transportation, and our primary witness was the engineer. I won't say his name, but he swore that those signs were properly sequenced, they were consistent with the manual, and the like.
So MDOT was sued for not having appropriate signs.
Correct.
And the theory was because the signs were not right, it confused her and caused her to drive into this. And then the construction company, they got sued because their driver drove over the lady.
Yeah. So the
Horrible case,
The
by the way.
judge
That's
had
horrible.
his verdict done. He says, "I won't read my verdict until the jury reaches their verdict." The jury gave a verdict for the plaintiff.
A lot of money.
A lot of money. A lot of money back in 1995, especially.
What judge was it?
Kalela?
Okay.
Does that sound right? Over in Grand Rapids, probably before you were
Before
practicing.
my practice, yeah.
And the judge hit us with a small verdict. Hit
Okay.
the department with a small verdict, and it resolved. Like it does. I mean,
So that's an interesting. So why did it take 6 weeks?
lots and lots of witnesses, and this will tell the cases. The other three lawyers in the case are all deceased.
No way.
I'm the only lawyer that I can recall from that case.
Who was the
that's
plaintiff's lawyer?
left. He's a guy who ended up joining my firm, Mark Verwise.
Okay.
About a year after that case, he joined our firm.
No way.
He was a fantastic trial lawyer.
That's a crazy case. But you can't sue MDOT for signage anymore, can you?
I don't think you can. I think that's changed since then.
That's changed.
Yeah.
I have a case. I'm trying to change that right now. Our Supreme Court, we don't get into politics on the show because we don't want to piss everybody off, because everybody gets pissed off talking about politics nowadays. And so no matter which side you're on. So
Yeah.
we don't, but the court the composition of our Michigan Supreme Court has changed. It is now in 1995. It's fair to say it was very defense oriented, right?
The Angler 4.
Angler 4, right? So you guys, when I say you guys, the defense bar, the insurance companies, the defendants, you felt pretty good about the court. You were getting pretty good decisions, right?
I would like to say we're getting a fair shake.
Mike, I love you, but I got to disagree. But now I think it's shifted where I would say the plaintiffs are getting a fair shake now, the injured people. But that's one thing that they did is it's crazy to me under the current law, and it sounds like this wasn't like 95, you can never sue for a design defect. So literally, just so our viewers understand, MDOT could build a bridge and the end of the bridge goes off a cliff, right? They could say, here's a bridge to nowhere. Here's a bridge to your death. And if you drove off the bridge, no signs, it could say, go straight ahead, and you drove off a cliff, you would have no remedy.
No
right?
remedy under that theory.
So we're trying to change that. I have a case right now where a little girl was riding her bike and the sidewalk suddenly ended into a ravine. So like you're walking on the sidewalk, there's no signs or anything. Suddenly there's a ravine. So it forces you to do what? Cross the street.
Yeah.
Or wade
die.
through the ravine or die. Yeah, right. Cross or die.
Yeah.
And so she crossed the street because they had a pedestrian bridge on only one side and there was no warnings. Make it even more interesting. The guy who lived at the end of the sidewalk, the guy where the ravine is, had written to the city on multiple occasions saying this is dangerous. People are having to cross the street and they're almost getting hit. So
busy road.
Very busy road. Yeah. My little girl crossed the street. There was a DoorDash driver going at a high rate of speed, trying to get that food, Chinese food to somebody, no joke, and smashed into her. Yeah. And so we settled with DoorDash, but we have I think this would be a good case. I mean, we hired experts to come out. They did a scene analysis. We took photos. It's very difficult, but we'll see what happens.
Well, that's the beauty of hiring you, John. You get thorough, and you have the ability and the knowledge and the connections to find the right people to go out and take a look at it. There's a lot of lawyers who would take that case and say, I'm going to get my cash from DoorDash and I'm going to move on. But you go the extra mile. That's really a tribute to you. It really is.
Thanks, man.
Yeah,
You do too.
yeah,
You do too. So we're almost out of time here. So let's talk about, I was in Oakland County. I was trying that case that I just talked about where we got 7.9. And for some reason, I ran into you at the courthouse and you were in the middle of a trial in front of Judge Warren.
Yeah. So I had a case where my client, it was a business case. My client was a minority shareholder or minority member of an LLC, and his majority owner, it's just two guys, kind of stiffed him out of a bunch of dough. And leading up to the trial, I'll never understand this. The opposing counsel sent me a bunch of emails saying, you don't know your case. You don't know what you're talking about. I'm going to kill your guy on examination. On and on and on. Well,
big talk.
Yeah. And for me, that doesn't scare me. It fires me up.
Yeah, I'm the same way.
Yeah.
When people say that, I go, okay.
Game on.
Game on. Let's arm up.
This particular lawyer, my client was on the stand who he promised to kill. And he said, I'm going to kill him. I'm going to get him to admit this and that and the other thing. When I had my client on direct examination, so I'm asking my client questions. There are two lawyers at the other table on the defense side. The younger lawyer is objecting. That's the lawyer who had been threatening me.
How young?
Well, he's probably 40 years old.
Yeah.
So I said, okay, I'm done with the witness. You can now cross-exam. The younger lawyer who had been threatening me doesn't stand up. The older lawyer stands up to do the exam. And I said, Judge, it's one witness, one lawyer. He goes, you're right. The older lawyer said, but I'm the one who prepared for this witness. I'm the one who has to question him. Judge said, that's not how it goes, but I'm going to let you do it. That guy was equally ineffective. He never was able to admit a single exhibit on behalf of his client to cross-examine my guy. And so
you guys didn't agree on exhibits beforehand?
We never had that relationship after he threatened me.
Yeah.
So we just put him in one at a time. Moved to admit exhibit one, moved to admit exhibit two.
That is such a slog.
It's a tough road to hoe. So ultimately the jury gave my guy a big verdict. And it's on appeal now. And we've got two judgments out there that are gaining interest that now are well over $3 million. They posted a cash bond, which is nice. And we'll see what happens.
So that was just a business. The guy stole money.
Yeah. One partner, the majority partner just kind of ran it like it was his own company instead of a partnership or LLC membership.
Right. But see, that's the thing about you, Mike. You do the business litigation, you do schools, you do education, you do employment, you do auto, you do MDOT running over people. You really do a lot of different fields, which for our viewers, it's very difficult. It would be like a doctor who does, heart surgery, brain surgery, back surgery, and then he looks at your feet and he's a podiatrist too. Here's
the beauty of our business. Every single day is different.
Yeah.
Every single day presents a different challenge and a different opportunity to learn something new. And so I really love that.
I do too.
I love it. I mean, you've tried cases. I mean, you got a guy getting pushed into a wall by a car. You got a lady with a religious exemption, right? You got employment cases of other kinds. You've got employment cases like Griffey. You know, I
got
think
Mullins hitting people in the head.
Right.
And you learn, like, dude, you and I now know
what a mullion is.
What a mullion is, and how a door frame should be installed at a public school.
Yeah.
And what happens when you don't, and how the screws slowly wear out, and one screw will fail, then a second one. That, you know, we know all this stuff that, like, I would never know, and I find it interesting, you know. And
I love it. I'm a lifelong learner. You're a lifelong learner. I mean, in that case, I also said, if I was ever going to draft a contract like this between a school and a maintenance company, I'd make sure these terms were in there and very clearly.
Exactly.
And so now when I go and talk to, so a lot of the schools I represent are through different pools. When I go talk to the pools, I tell them, listen, when you get these contracts, let's take a look at them and make sure you're really protected. Like, for example, there's a company out there that supplies substitute teachers. And believe it or not, John, sometimes those substitute teachers do bad things in the schools.
Those are like the big,
you know about those. Yeah. And so I want to make sure that company protects us. If your substitute you send to us does bad things, that's on you.
Right.
You got to protect the school.
Right.
We hired you for this expertise. You got to make sure you do it.
Right.
And their contracts all say we do an I-chat, you know, a criminal background check. We do this and that, and we train them. But I think the contract should go beyond that and say, if this person does anything, you step in immediately and you
protect us. You're responsible.
That's a struggle.
That's a struggle. Well, hey, man, I have a feeling we're going to be very busy.
Always.
Mike Weaver, great attorney, great law firm, Plunkett Cooney. Thanks for coming on the show,
Pleasure, man. Thank you for having me.
You're a good lawyer and a good man.
You are. See you, man.
All right, everybody. Thanks again. What a great show today with Mike Weaver from Plunkett Cooney. Thanks for listening to Cases Gone Wild, brought to you by me, Jon Marko. If you or somebody you know needs help, you have any of these a plethora of problems that we discussed, please go to my website, markolaw.com. Reach out to us. We'll see you next time in another 2 weeks on another Cases Gone Wild.